Hey everyone, I'm Ashley Abraham. I'm a former DUI prosecutor, and today I want to cover a topic that's essential for every driver to understand: Tennessee's implied consent laws. These laws impact every driver on the road, and knowing your rights and responsibilities can be crucial if you ever find yourself in a situation where you're stopped by law enforcement on suspicion of DUI. What is implied consent? Implied consent is a legal concept that essentially means by choosing to drive on Tennessee's roads, you're automatically agreeing to submit to chemical testing if law enforcement has probable cause to believe you're driving under the influence. This concept is governed by Tennessee Code Annotated 5510-406 and often referred to as implied consent law. Under this law, any person operating a motor vehicle within Tennessee is considered to have consented to an alcohol or drug test, typically a blood or breath test, if they're arrested under suspicion of DUI. In simple terms, if you're pulled over and the officer has reason to believe you may be intoxicated, you are required by law to submit to one of these tests if you're asked. Refusing to do so has serious consequences, which we'll discuss shortly. When does implied consent apply? The implied consent law doesn't mean that an officer can request a test without any grounds. For a test to be legally requested, the officer must have what's called probable cause. This means they must have specific observations or evidence suggesting that you're driving under the influence. Probable cause could include erratic driving, the odor of alcohol, slurred speech, or failing a field sobriety test, among other signs of impairment. It's also important to note that implied consent only applies when you're actually placed under arrest. If an officer simply pulls you over but doesn't arrest you, you're not obligated to take a chemical test under implied consent. What happens if you refuse to submit to a test after being arrested? Refusing to take a chemical test when requested by law enforcement can lead to an immediate suspension of your driver's license. In Tennessee, this is known as a refusal suspension, and it carries penalties separate from those related to any DUI conviction. If it's your first refusal, your license will be suspended for 1 year. However, if you have a prior conviction for DUI or other aggravating circumstances, like causing an accident that resulted in injury or death, a refusal can result in a 2-year license suspension. Keep in mind that even if you ultimately avoid a DUI conviction, a refusal can still lead to a suspension of your driving privileges. So, the penalties for refusing are significant, and they're intended to deter drivers from refusing chemical tests when suspected of DUI. What are exceptions to implied consent? While the implied consent law applies broadly, there are some situations where it doesn't. For example, if a driver is unconscious or otherwise incapable of making a decision, law enforcement can typically administer a chemical test without obtaining explicit consent. This is because courts generally rule that an unconscious person's implied consent still holds, and it's often considered in the interest of public safety. Also, if law enforcement seeks to obtain a blood sample and the driver refuses, officers may seek a warrant from a judge to require the test. In recent years, the United States Supreme Court and Tennessee courts have clarified that law enforcement must obtain a warrant for certain types of tests if a driver refuses, especially for more invasive tests like blood draws. However, in many cases, officers can obtain this warrant quickly, and refusal might ultimately lead to forced compliance if a warrant is granted. So what are the defenses against implied consent violations? If you've been charged with a refusal under implied consent, there are some potential defenses. For example, lack of probable cause. If an officer didn't have legitimate probable cause to arrest you for DUI, you may have grounds to challenge the test request. Failure to explain rights. In Tennessee, officers are required to inform you of the consequences of refusing a test. If they fail to explain this, the refusal may be invalid. Additionally, medical reasons. In some cases, if you have a valid medical reason for refusing a specific type of test, such as a blood draw, that may be a valid defense. However, each case is unique, and if you find yourself facing a refusal suspension, it's best to consult with an experienced DUI attorney who can evaluate the details of your case and advise on the best course of action. The implied consent law is designed to help law enforcement combat impaired driving, but it places a serious responsibility on drivers. Here are a few things to keep in mind. Understand your rights. If you're arrested for DUI, you do have the right to refuse a blood test, but remember that refusal comes with its own penalties, including a license suspension. Number 2, know the consequences. Refusal isn't always the best choice, especially if considering that it can lead to a longer license suspension than you might face with a first-time DUI. Number 3, cooperate with law enforcement. While you're not required to perform field sobriety tests or answer questions about alcohol consumption, implied consent does require you to submit to a blood test upon arrest. Implied consent in Tennessee means that by driving, you've agreed to testing for substances if arrested under suspicion of DUI. Understanding this law can save you from unnecessary penalties and suspensions. If you or someone you know faces issues related to implied consent or a DUI charge, consult a knowledgeable attorney who can guide you through the process and ensure your rights are protected.